Good evening, everyone. I'm Alan Price, Director of the John F. Kennedy Presidential Library and Museum, and on behalf of all my library and foundation colleagues, I thank you for braving the weather to join us this evening. I would like to acknowledge the generous support of our underwriters for the Kennedy Library Forum's lead sponsor, Bank of America and the Lowell Institute, and our media sponsors, the Boston Globe, Xfinity, and WBUR. I'm also delighted to welcome all of you who are watching tonight's program online. Akhil Amar and Eric Foner have kindly agreed to sign copies of their most recent books after tonight's program. Our bookstore will be selling copies if you are interested. We thank you all for silencing your cell phones. I have to say, you've done a great job all season. Let's keep it going. We are so pleased to have this timely opportunity to explore constitutional questions in depth this evening, in light of the current discussions on constitutional issues occurring at the federal level. I'm now delighted to introduce tonight's speakers. Akhil Amar is Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law in both Yale College and Yale Law School. His work has won awards from both the American Bar Association and the Federalist Society, and he has been cited by Supreme Court justices across the spectrum in more than 36 cases, tops in his generation. He regularly testifies before Congress at the invitation of both parties. He has written widely for national publications and served as an informal consultant to the TV show The West Wing. And his constitutional scholarship has been showcased on a wide range of national broadcasts. He is the author of dozens of law review articles and several books. Eric Foner, DeWitt Clinton Professor Emeritus of History at Columbia University, is one of this country's most prominent historians. He is one of only 2 persons to serve as president of the 3 major professional organizations, the Organization of American Historians, American Historical Association, and Society of American Historians, and one of a handful to have won the Bancroft and Pulitzer Prizes in the same year. Professor Foner's publications have concentrated on the intersections of intellectual, political, and social history, and the history of American race relations. His most recent book is The Second Founding: How the Civil War and Reconstruction Remade the Constitution. I'm also pleased to welcome back and introduce our moderator for this evening. Kenneth Mack is the inaugural Lawrence D. Beale Professor of Law and Affiliate Professor of History at Harvard University. His research and teaching have focused on American legal and constitutional history, with a particular emphasis on race relations, politics, and economic life. He is the author of Representing the Race: The Creation of the Civil Rights Lawyer, and co-editor of The New Black: What Has Changed and What Has Not with Race in America. He is currently working on a book that examines the social and political history of race and political economy in the United States since 1975. Please join me in welcoming our special guests.
Well, first, thank you to Director Price and to the Kennedy Library for inviting me back here again. It's a pleasure to be here with such illustrious company. I'm going to start by asking each of our guests to talk about their recently published books, which, as Director Price told you, they're going to be signing afterwards. The Second Founding by Eric Foner and The Constitution Today by Professor Akhil Amar. So I want to start with Eric. Just explain a bit about what we should take from your book, The Second Founding. Mm-hmm. You cite a number of achievements of the Second Founding: birthright citizenship, equal protection of laws, the right to vote, a reorientation of the relationship between the federal government and the states. And you even have this sort of wonderful story about, once Congress understands it's going to undo the 3/5 compromise with emancipation, then of course there's overrepresentation because, if African Americans don't vote, we've got this problem. So you've got all of this wonderful detail about the 13th and 14th and 15th Amendments. But what does this history tell us that the larger reading public needs to know now?
Well, first of all, thank you for taking part in this, and to the Kennedy Library for having us. I am, unlike my two colleagues here, I am not a law professor, I'm not a lawyer, I've almost never been in a courtroom, very law-abiding person, and so I come at it maybe from a slightly different angle. I'm a little intimidated about constitutional issues here, but on the other hand, the takeaways, I guess, that I want from my book are just, let's say, three to begin with. One is what you mentioned already, that the issues, the key issues of the Reconstruction era right after the Civil War, which led to the rewriting of the Constitution through the 13th, 14th, and 15th Amendments, are still on our agenda today. It's hard with these lights to see exactly who's in the audience and what ages you are, but at least some of you will understand when I say that these questions are on the front pages of our newspapers. And who is a citizen? Who should be an American citizen? That's being fought out on our borders every day. Who should have the right to vote? What is to stop states from denying large numbers of people the right to vote? That is the voter suppression is happening in many states as we speak. Terrorism, how should we be dealing with terrorism? This was an era of considerable terrorism, not from abroad, but good homegrown American terrorism, the Ku Klux Klan and groups like that. White nationalists, violent white nationalists were very prominent in this period. So in other words, I think that to understand where we are today, one needs to know something about that period 150 years ago. But the second point is simply that everyone knows, I guess, who has any education, that there were amendments to the Constitution, but these three amendments, the 13th, 14th, and 15th, do not occupy the same sort of place in our public consciousness as, let us say, the Bill of Rights or other parts of the Constitution. The people who wrote them are hardly household names: John Bingham, James Ashley, Henry Wilson. They're not known like Madison and Hamilton. Of course, they didn't have a hip-hop musical about them. But, we need to know about what happened, because these amendments really, in my opinion, transformed the Constitution, really created the Constitution we live under today. And too often, I think, the Supreme Court, or at least some people on it and others, kind of ignore those amendments when they're trying to talk about, let us say, the federal system. They go back to 1787 as if nothing changed in the Constitution as a result of the Civil War. So, I just think that people need to know more about how the Constitution will change. And the final point is simply, one of the sad lessons of this is that rights in the Constitution are not self-enforcing, and rights can be gained as they were, but rights can also be taken away as they also were in the late 19th, early 20th century. So that, under a conservative Supreme Court, many things that we take for granted may not actually be as secure as we think, and this history is a sad example of that fact.
Actually, I want to jump in just in that exact point and ask Professor Amar a question before we get to your book. You've sort of done something along the same lines, the originalist jurisprudence ignoring the changes in the constitutional structure wrought by particularly the 14th Amendment. Can you, in some measure, you've tried to revive interest in these amendments as well. Can you talk a bit about that?
Thank you, and it's such an honor to be here, and it's a perfect segue, because the first thing I wanted to tell everyone is what an honor it is to be with one of my heroes, Eric Foner.
Thank you, Akhil.
And the work that you alluded to is inspired by Eric Foner. And I wrote a book a long time ago called The Bill of Rights, Creation and Reconstruction. And one of the proudest moments of my life was when Eric agreed to blurb the book. And here's what the book is about, and it's captured by the title. First of all, it doesn't call itself the Bill of Rights, the first 10 amendments. When you look in your copy, it doesn't say that. Why do we call it the Bill of Rights? And the answer, and the Supreme Court never not once referred to it as the Bill of Rights before the 1860s. And now that's what everyone calls it, because the framers of the 14th Amendment, because a man named John Bingham, whom we just mentioned, kept referring to it as the Bill of Rights. So what's creation and Reconstruction? Well, the idea is that the structure of that book was part one, part two, and you might think of it, here's an analogy, if you're a Christian, Old Testament, New Testament. Okay, there's the Old Testament, and it says a certain thing, and then actually you've got a new set of texts that has to, that obliges you to reinterpret in certain ways what the earlier texts say. So there's creation, Old Testament, then there's Reconstruction, a second founding, if you will, a new birth of freedom, a reconstruction, a reconstitution, if you will. So if you're a Christian, you read the book of Isaiah, which says that a young woman shall give birth through the life and death and ministry and resurrection of Jesus, and you read it as if it says, a virgin shall give birth. Or you read the 10 Commandments as if there's an 11th like unto them. Or you interpret the personality of God, Yahweh, through the prism of this reformist rabbi who says, actually, it's sort of Abba, Father. So we, as Americans, here's what we don't have in common. We don't have race in common. We don't have religion in common. We are many religions. We are many different language groups. Our forebears came to the New World at very different times in very different ways, from the Native American experience to the slave experience to the immigrant experience. That's my parents. That's why I was pointing to my own chest. So we don't have race in common. We don't have religion in common. We don't have ethnicity in common. We don't even have language in common. What we have in common is a narrative, a certain story. We are all Americans, and Eric had persuaded me by his work that I am not just a child of the founding fathers of Washington and Hamilton and yes, Jefferson too, that's more complicated, but also of Lincoln. That's who we are as Americans, and Lincoln and his generation have to be thought of pretty much at the same level as the second founding as Washington and Hamilton. And that's, yes, that is my work, and I just have to tell you all, I'm getting it all from Eric Foner. He said
this
it
is
first.
an exaggeration, folks.
You came first.
Okay. So let me ask you a follow-up question about your book, Akhil. In your book, Constitution Today, you describe yourself as a constitutional journalist.
Yes.
And in some measure, in this book, you gather lots of things that you've written before, you rework them into a whole. And I'm going to ask sort of the same question I asked Eric. You talk about history, text, structure, but this is a book for a general audience. What does a general audience get out of reading your book? What do you want them to know after finishing it?
This is a book, as you said, Ken, that is a work of journalism of a certain sort. My earlier books were really inspired by people like Gordon Wood and Eric Foner. They're history books of a certain sort. So they tell you a lot about the founding, a lot about the Reconstruction, the era, the progressive era, which gives us women's suffrage, direct election of senators, and income tax. So they're history books written by someone who's law trained. This one is different. It collects op-eds that I've written over the last 25 years on the hot button issues of my lifetime. And it's dedicated to another one of my heroes, Bob Woodward. So it's in a journalistic tradition. Because one problem is history doesn't always, and when I write a history book, I'm not always telling you, and here's what that means you should do today. Here's how you should, the Supreme Court should decide this case, or here's how the senator should vote. that's important also. So this is a book all about basically the applied issues of my lifetime, and I sort of reorganize them in a certain way. So the last 3 chapters, for example, are about our 3 most recent presidents before the current one. This came out in 2016. And a big constitutional question connected to each of them. For Barack Obama, it was Obamacare. So I have a whole bunch of op-eds about Obamacare while the thing was unfolding, the debate. And before that, it was W. And I think the big constitutional issue for him is why was he declared the victor when Al Gore got more votes? So what is it about this electoral college thing? So I had a whole chapter on W and the electoral college. And for Clinton, I don't know if anyone's thought about this at all recently, probably not, but he got impeached. So I wrote about the impeachment process and actually why partisan impeachments are actually problematic. So those are the last 3 chapters. There are other chapters in which I tell you about how to think about criminal procedure reform or filibuster reform or presidential succession or executive privilege, just all the issues of the last 30 years that have popped up.
Okay, great. So let me ask another question of Eric. This is it's a popular book in some measure, sort of unlike most of the things you've written. No, they have been immensely popular. They sold more than any book I'm ever going to write. But they've been directed more to an academic audience.
Right.
This is directed more to a general audience. What's different about this book than your prior books?
Well, it's a lot shorter than many of my previous books because attention spans have diminished a little bit lately. I tried to write it. I mean, of course, one always wants as many people to read your book as possible, but you're quite right. It's not nearly as heavily footnoted, and it hones in on just these 3 amendments. It's not a whole history of Reconstruction. I did do that at considerable length with a lot of footnotes one time. It's really, now to say this is immodest, and don't get me wrong, but my model for this book was actually The Strange Career of Jim Crow by C. Van Woodward, which is a book based on scholarship. I mean, Woodward was a great historian, but written for a general audience, and if I sold as many copies as that, I'd be very happy. But that was a model for me of clarity of writing, of not overburdening the book with too much in the way of original evidence and everything, and trying to have a straight an argument that runs all the way through it. So I did write with because I feel that again, I'm not a lawyer for that these amendments have been in many ways misinterpreted or misused by the Supreme Court. And I'm not just talking about 1900 and 1905, and one can list the cases back there. I'm talking about now, and partly because we live in a jurisprudence of precedent, and therefore what I consider bad decisions of the past are still affecting decisions today. But, so in a way, the book is political also. It's not an argument to vote for this person or that person, but it's about where that there is an alternative way of looking at these amendments that the Supreme Court, that is rooted in the actual history, but that the Supreme Court has never fully adopted. And I hope maybe in the future, with a somewhat different composition of the Supreme Court, they might decide to take a look again at this.
Oh, well, that's a great segue into my next question, which is really directed at both of you, because we're talking about history here. And there certainly is a variety of history that has interested many of the justices of the Supreme Court, and we call that originalism. Both of you distinguish your work from originalist jurisprudence, at least the variety of it invoked by some of the conservative members of the present members of the U.S. Supreme Court. Can each of you distinguish what you're doing? How is the history that you're using different than originalism? So I'll ask Akhil first and then Eric second.
Mine is a kind of originalism. There's actually an essay here on liberal originalism. The Warren Court, in my view, was actually driven by a liberal originalist of sorts. So he always carried around a copy of the Constitution with him. What an odd duck that kind of person would be. His name was Hugo Black. He was FDR's first appointee to the court. He was a former Klansman, and he was not altogether honest in his confirmation hearings. That sort of thing happens. And yet, I would say he was maybe the greatest justice of my lifetime. And he's the driving intellectual force of the Warren Court. And he helps the court make amends for some of these precedents that Eric talked about. So in 1953, before Warren, let me tell you, 1936, 37, before Hugo Black comes on the court, this is America. There's massive segregation for much of America, Jim Crow. There's no right to vote that's enforced, and it's not one person, one vote. There's massive malapportionment in many places, and some malapportionment almost everywhere. The Bill of Rights doesn't generally apply against state and local governments in court, only against the federal government. There's organized sectarian prayer in the schools, which is not really equal. The freedom of expression hasn't really been robustly protected by the Supreme Court. And criminal defendants have precious few rights, they don't even have, if indigent, a rights to a government counsel, a lawyer at public expense. Now, the Warren Court changes all of that because Hugo Black reads the text. And he says, you know, it says free speech. Let's do free speech. It says right to vote. Let's do that. It says religious equality, free exercise. Let's protect that. It says no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, fundamental rights. Let's apply those against states as well as the federal government. Gandhi was once asked what he thought of Western civilization. And he paused for a moment. He said, I think it would be a good idea. Well, that's Hugo Black's thought, that they're actually, some of these things like the right to vote, freedom of speech, freedom of the press, these are good ideas. We should do them. Now, that's originalism of a certain sort. It's repudiating precedents in the name of what the text says and really was all about. How is my version any different than standard originalism a la Bork or Scalia or Thomas? Maybe two things. One, because I'm a student of Eric Foner's as well as Gordon Wood's, and Gordon, I would say, is the great historian of the founding era, as Eric is of the Reconstruction. I try to give equal weight to the amendments, especially the Reconstruction amendments, the second founding. I would say a third founding with women's suffrage. You know, we need to take seriously the original vision behind women's suffrage, which is that women should be politically equal. I think that would be a good idea, you see. And some self-described originalists stop with the founding era, and Eric is trying to say that's a mistake. That's, you know, what he's saying. The second founding, and that's the Reconstruction, the Reconstitution. So that's one difference. I think I try to pay more attention to the later generations of constitutional texts, to the amendments as well as the original document, which has slavery, of course, in it. And ours is an anti-slavery constitution, thanks to Lincoln and Bingham and Ashley and Sumner and the people that Eric mentioned, and Thaddeus Stevens and others. Second, I try to read the Constitution holistically, see it as one unified system rather than clause by clause. So I tend to look less at dictionaries. Scalia did that because that was easy to do. But if you really are an originalist, you believe in history, you're going to have to study it in great detail. You're going to have to read Eric Foner's books and then reread them. Okay, you don't have to buy them at the library. You can get them at the library.
No.
You have to buy them. Okay, you have to buy them. Okay, originalists believe, and if we don't do that, we're doomed, I believe, because that's what we Americans have in common, is American history. And my forebears weren't here, but I can still claim that narrative, that project. But if I'm going to do it, if it's going to be common ground for all of us, we're going to actually have to know what really did happen at the founding, in the Reconstruction, in the Progressive era. We're going to actually need to, and that's why it's so important that people like Eric write stuff that's actually accessible to the rest of us. This book pulls together these op-eds just so that Each one will take you 3 minutes to read at most. You can read it on the potty, okay? And that's how this generation, they don't want to read a big long book, but maybe just like a little bit at a time. It's like social media or something, just little snippets at a time. So, but you and I do have obligations actually to try to get out.
That's our job.
Yes.
Absolutely.
To the citizenry.
Yeah, I don't, when I was working on this book, I kept wondering or thinking about how do I avoid the originalist trap? That is to say, to think that the Constitution today can be understood simply by going back 150 years or 200 years and finding what people said back then. Now, to me, the idea, now again, I'm not a lawyer, et cetera, but the idea of originalism is intellectually incoherent because no historian believes that any significant document has only one meaning or one intent. And if you take these 3 amendments, I mean, they were all compromises. There was all sorts of input into them from different groups of people, different groups of Republicans. The 14th Amendment, which became far more important than the other 2, was a series of compromises between different factions in the Republican Party. It's very hard to specify a single intent there, but on the other hand, as a historian, it's a legitimate question to just say, well, what were they trying to accomplish?
Let me pick one, for
what
example.
What were they attempting to do by putting these in the
That
Constitution?
you mentioned earlier.
Yeah.
So, and I take this very personally, and this may be why I actually do what I do. On the day that I'm born, the United States Constitution gives me this great gift. It gives me the gift of citizenship. I am a birthright citizen, even because I'm born in Ann Arbor, Michigan, full stop. My parents are not citizens at the time. They weren't even green card holders. Now, truthfully, they weren't here illegally, but they were just students at the time. And I take it that it's not a close question, and this is originalism. The text of the 14th Amendment, the first sentence, really does say everyone born in America and subject to the jurisdiction thereof is a citizen, and that's confirmed by the history. Well, that's originalism, and if we don't say that, we can't say, and I'm going to say it, President Trump is completely wrong on that.
Right.
And that's originalism of a certain sort.
No, that is completely right. But I guess my other point about this, here I was influenced by Professor Mack's writing, that we have to, if we want to find out what the intent or the original meaning was, we've got to get outside the beltway, not just look at too many, with all due respect, law journal articles about this. Think that if you find a quote from Bingham or you find a speech from Howard or whoever it is, there is your original intent. It's within Congress. But, the whole country was debating these issues. And how do you get an African-American voice into this discussion? There was not a single black member of Congress when the 14th Amendment was enacted. And yet, without black voting, no 14th Amendment, because it required the ratification by states where, due to the Reconstruction plan, new governments have been created with black men holding office and voting. What did African Americans think the intent of these things was? So that we've, as a historian, if we're looking for the, purposes, we've got to go very broadly. I know that you two agree with me because but there are too many legal scholars have a slightly more narrow view of this, and certainly justices. I don't think Justice Scalia was looking at the Mississippi legislators' debates.
But let's just take
about,
that, even specific, because here's what's amazing. The word race does not appear in the 14th Amendment.
Right.
Now, it does in the 15th, race, color, previous condition of servitude. It does in the Civil Rights Act of 1866, which talks about people of various races having the same rights as people of the white race. But the text itself doesn't say race, and yet nothing could be clearer. I think we would agree that the black codes and the status of former slaves who were blacks was at the heart of and that's originalism of a certain sort. You won't find it in a Scalia dictionary,
Right.
but you will find it in the work of Eric Foner, and others.
But as you well know, each of those 3 amendments ends with a section saying Congress will have the power to enforce
Yes.
this amendment. That guaranteed that this is an ongoing process.
Yep.
In other words, the original intent is not frozen at the moment of ratification.
It's by Congress for
right?
Congress.
Congress can continue to act in this way and does. I mean, in 1875, they passed a new Civil Rights Act which does things that actually most of them didn't think they wanted to do 10 years earlier, and yet they said, look, being a citizen, this was to ban discrimination by public accommodations and transportation companies on the basis of race. This is part of what it is to be a citizen, they say, in the United States, to be treated with respect in the public sphere, and the 14th Amendment allows us to do that. Now, later the Supreme Court said, no, you can't, but...
And you and I both think that's a tragedy. In
Right.
1875, thanks
Right.
to a Massachusetts senator named Kennedy, Sumner,
Right on.
this thing is passed, the Supreme Court invalidates it, and it won't come back into our law until Lyndon Johnson, using the legacy of John F. Kennedy, actually gets that law passed as the Civil Rights Act of 1964, even though in large part it simply says again what the Civil Rights Act of 1875 said first. And
Right.
you and I think Congress was right the first time.
And
The
it was a
court was
terrible
wrong
decision,
to
right.
invalidate all of that. But the ground on which we stand is it says Congress shall have power to enforce this.
Right.
Those
but,
are the words.
Even the Warren Court, as you well know, was not willing to say, we were wrong back then in 1883.
Correct. They hate admitting they're wrong.
They go around the old decision rather than saying, look, our predecessors here really blew it, folks, and we're going to start again and really talk about what these amendments are about.
And that's why you and I, the last time I testified before Congress, I actually said that I thought, this is what I first said, you can see it on C-SPAN, I catch myself. I said Shelby County, which is a decision which the Supreme Court invalidated parts of the Voting Rights Act of 1965, which Lyndon Johnson got through as a tribute to John Fitzgerald Kennedy. They invalidated parts of the Voting Rights Act of 65 in a case called Shelby County. This is what you began with, talking about voting rights.
Right.
And in my testimony, I said, this is the worst case in the last 20, and then I caught myself, and I said 15 years, because I don't love Bush versus Gore either. so you'll see me actually, I catch myself.
Right.
So, but that's because you and I believe that when you look at the history, it really is clear that the words mean what they say. Congress has power to enforce this, and that meant something.
But then there are words in these amendments, 14th particularly, of course, which don't really explain themselves at all. Privileges or immunities of citizens.
They're open.
What are those? And there was vast disagreement. I mean, as you know, in the last chapter of the book, I talk about this group of black lawyers in Baltimore, the Brotherhood of Liberty. I love their name, the Brotherhood of Liberty. They published a big book criticizing the Supreme Court, which said, the privileges and immunities of citizens include the right to get a good job, the right to an education, things that the Supreme Court has never said are your constitutional rights, And yet this is, at the time, other people are saying, no, this is, to be a citizen, here's what you must enjoy. So, to say, there were a lot of different original intents out there in that period. And,
but we can
in a sense, it's a political
question
which one you want to pick up on.
We can clearly say some things are pretty clearly in.
Right.
So free speech is in.
Yeah.
And here's, one reason. I remember reading, Eric, one of your first books on the free soil. Okay, so this is the Republican Party slogan, like, hope and change, or make America great again, or we like in 1856, the Republican Party for the first time fields a presidential candidate, John C. Fremont, the pathfinder to the West, and their slogan, this is what we believe: free speech, free press, free soil, free labor, free men, Fremont. Okay, so that's, again, you won't find it in a dictionary, but if you read Eric Foner's work and you study history, you say, they clearly thought, surely, that if anything was a privilege or immunity of citizens, that no state should abridge. Free speech and free press have to be up there. Now, exactly how far you go, but we can start by saying this is clearly in, this is clearly in.
Right.
You know, we're in favor of Western civilization. We're in favor of religious free exercise, and we're in favor of due process and jury trials, and some of those things are pretty clearly in.
Mm-hmm. Yeah.
Okay. All right. Great. We could keep going, but I think we should move to the elephant in the room, which is
yes.
impeachment, of course. which
That
we will
elephant.
Certainly. Get questions from the audience about this in the Q&A. But I would just start by noting that both of you have relevant expertise on the subject of impeachment. Eric, certainly on the impeachment of Andrew Johnson during the Reconstruction era. Akhil has written about this as well. Akhil is of course, an expert in the history, text, and structure of the Constitution. But of course, I noticed there was a recent op-ed in Common Dreams where someone says, why doesn't the Judiciary Committee call Eric Foner? They need to call Eric Foner. They haven't called a historian. They should have said, why don't they call Eric Foner or Akhil Amar?
Right.
So each of you,
Here's our chance.
yes, what does your work say to our present debate about impeachment? What's not being said? What could Congress or the public or President Trump learn from your explorations of history?
I really think Akhil knows a lot more about impeachment than I do. I know a lot about the impeachment of Andrew Johnson. My former student, Manisha Sinha, who teaches
Brilliant.
at Connecticut, wrote
Brilliant person.
a very good article a couple of weeks ago in the New York Times comparing President Trump and Andrew Johnson, and they do have a number of qualities in common. In fact, I used to think that Andrew Johnson was the worst president in American history. But now there's a fight for that designation. But, you know, the impeachment of Andrew Johnson was quite different. Number one, Johnson had no party behind him at this time. He didn't have 53 or whatever it is members of the Senate, as Trump does, who it seems are never going to vote to impeach no matter what happens. Johnson was elected as a Republican, sort of, with Lincoln, even though he'd been a Democrat all his life, but a Unionist, stayed with in the Union when his state, Tennessee, seceded, was military governor of Tennessee under Lincoln during the war, and was put on the ticket as vice president because, as a way of trying to appeal to what many Republicans thought was a large number of white Southerners who really had opposed secession and might join up with the Republican Party after the war. You know, people are put on the ticket as vice president to appeal to one group or another group. That's pretty typical. But Johnson turned out to be deeply racist, deeply incompetent, unable to work with Congress, no sense of public sentiment, and fought Congress all the way on Reconstruction policy without going into all the details. And basically, Congress just got fed up with him. And, even though the articles of impeachment, apparently there's only going to be 2 articles of impeachment I read today on my phone, which may or may not be accurate, but there were 11 against Johnson, and most of them had to do with violating the Tenure of Office Act, a specific law, although most people thought that law was kind of questionable anyway. But the 11th, was really why they wanted to get rid of him, because they just couldn't stand the guy anymore. But he was impossible, he was incompetent, he was constantly badgering Congress, insulting them, he was trying to obstruct the implementation of congressional Reconstruction policy. But the question is that impeachable? Just being impossible, and someone that you'd like to get rid of. So they actually put all this violation of the law in. But I don't know, actually, even I'm a historian, if there are that many lessons one can learn from the impeachment of Andrew Johnson. Johnson, of course, was not convicted. They came 1 vote short of the 2/3 required to convict and remove from office. although it's pretty clear that a kind of a deal was made between a number of Republican senators and Johnson's lawyer, William Evarts, who was a very prominent attorney at the time. And Evarts basically promised, look, if you let this guy stay, it's only a few more months in his term, he will behave himself, I promise. He's not going to cause any problem. And in fact, he did. He shut up after that, and he didn't bother Congress, and they went forward with their plan of Reconstruction. So the acquittal of Johnson really didn't have much effect. I mean, things kept going. So I'm not sure. I'm interested in what Akhil says here, and also Kenneth, about what the current status of impeachment is from a constitutional point of view.
Akhil.
So I'm going to ask Eric later, because one thing I've never fully understood, I've tried to find out this, is to what extent Lincoln himself pushed Hannibal Hamlin off the ticket and said,
We don't really
you
know.
I want